The judge is denying a request for a mistrial in the E. Jean Carroll civil battery and defamation case against former President Trump. The author is accusing Trump of raping her in the 90s and then defaming her when she wrote about it, accusations Trump denies. Trump's attorney, Joe Tacopina, had asked for a mistrial, saying the judge mischaracterized elements of the case and improperly shut down certain lines of questioning during cross-examination.
This is totally devastating. We need to talk about a series of court orders that came down in late 2025 that terrified Trump and his legal team. And these orders are crucial to understanding how Trump ended up where he is today. Because what happened in October, November, and December of 2025 was that multiple federal judges started issuing what legal experts call compelled testimony orders with contempt sanctions. What does that mean in plain English? It means judges were ordering Trump to testify under oath in various investigations, and the judges were making it crystal clear that if Trump refused to testify, he would be held in contempt of court. And contempt can mean jail, immediate jail, not after appeals or delays. Immediate incarceration for defying a court order. And here's what makes this absolutely more devastating. Trump had never faced that level of direct judicial pressure before. Throughout his career, Trump had always been able to delay appeal, negotiate, and ultimately avoid having to testify under oath in situations where his testimony could be damaging. His lawyers were experts at finding procedural ways to keep Trump off the witness stand. But starting in October 2025, judges stopped accepting those delay tactics. They started issuing orders with extremely tight deadlines: 48 hours to appear, 72 hours maximum. And if Trump didn't show up, U.S. Marshals would be sent to arrest him for contempt. This was a complete shift in how courts were treating Trump, and it sent shockwaves through his legal team because they suddenly realized they had no way to protect Trump from having to testify. But real quick, before we get into this, let's be honest. You can't really trust mainstream media anymore. That's why we built John Brown's show to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, please subscribe, because you might think you are, but aren't. Your subscription actually matters here. All right, let's get into what's actually happening. And testimony under oath is incredibly dangerous for Trump because Trump lies constantly. And if he lies under oath, that's perjury. That's a federal crime. But if he tells the truth under oath, he incriminates himself in the fraud and money laundering schemes he's been running for decades. So Trump was caught in an impossible situation: testify and either commit perjury or confess to crimes, or refuse to testify and go to jail for contempt. There was no good option, and Trump's panic was visible to everyone watching. Now let me walk you through the first major compelled testimony order. It came on October 16th, 2025. This was from Judge Arthur Engoron in the New York fraud case. Engoron had already ruled in 2023 that Trump committed fraud by inflating property values, but in late 2025, Engoron was conducting additional proceedings related to calculating damages and identifying other potentially fraudulent transactions. And Engoron ordered Trump to appear for a deposition under oath to answer questions about how he valued Trump Tower specifically, because evidence had emerged that Trump claimed Trump Tower was 30,000 square feet when it was actually only about 11,000. Trump had literally tripled the square footage on paper to inflate the property's value for loan purposes. And Engoron wanted Trump to explain under oath how that happened. And Trump's lawyers tried every procedural trick to avoid the deposition. They filed motions claiming Trump was too busy with presidential campaign activities. They argued that forcing Trump to testify would violate his Fifth Amendment rights. They claimed the questions were overly broad and burdensome. Every excuse they could think of. And Engoron rejected all of it. Think about what that means. On October 16th, Engoron issued an order saying that Trump must appear for deposition within 72 hours, 3 days. And if Trump failed to appear, Engoron would issue a warrant for Trump's arrest for contempt of court. And the order specifically said that contempt sanctions would include immediate incarceration pending compliance. That means Trump would be jailed until he agreed to testify. No bail, no appeals, just jail until you testify. And that order absolutely terrified Trump's legal team because they knew it was enforceable. Share this video with everyone you know, because here's what makes that October 16th order so significant. It established a precedent that other judges quickly followed. because once Engoron showed that courts were willing to use contempt threats to force Trump to testify, other judges in other cases started doing the same thing. On November 22, 2025, Federal District Judge James Boasberg issued a similar order in a different case. Boasberg was overseeing litigation related to Trump's deportation policies. Specifically, there were allegations that Trump and his administration officials had defied court orders by continuing deportations that judges had specifically blocked. And Boasberg wanted Trump and several of his cabinet officials to testify under oath about who authorized the deportations despite the court orders. And Boasberg gave them 48 hours to appear, 2 days. And Boasberg's order used even stronger language than Engoron's. Boasberg wrote that willfully disregarding court directives would result in possible imprisonment and substantial financial penalties. And Boasberg made clear that he was prepared to have U.S. Marshals arrest Trump and his officials if they didn't comply. This was a federal judge threatening to arrest a sitting president for contempt. That's almost unprecedented in American history, and it showed how seriously courts were taking Trump's pattern of defying judicial orders. Then on December 5, 2025, yet another judge issued a compelled testimony order. This time it was related to the Deutsche Bank financial records investigation. Prosecutors wanted Trump to testify about his relationship with Deutsche Bank, and specifically about the loans he received and how he qualified for those loans given his history of defaults and bankruptcies. But here's the thing. Trump tried to refuse by claiming executive privilege. He argued that conversations with his bankers were protected because they related to his business activities while serving as president. But the judge rejected that argument completely. The judge ruled that executive privilege doesn't protect conversations with private banks about personal financial matters. And the judge ordered Trump to appear for a deposition within 72 hours or face contempt sanctions, including immediate arrest. And at this point, Trump's legal team was in complete panic mode because they had 3 different judges in 3 different cases all threatening to jail Trump if he didn't testify. And the deadlines were overlapping. Trump couldn't possibly appear for all these depositions on the tight timelines the judges were demanding. So Trump's lawyers started filing emergency appeals, trying to get higher courts to intervene and block the contempt threats. But the appeals failed. Appellate courts basically said that trial judges have broad discretion to compel testimony and sanction noncompliance. And if Trump thinks the orders are improper, he can appeal after complying. But he has to comply first. You can't just refuse a court order and then appeal. You have to follow the order and appeal simultaneously, and that meant Trump was out of procedural options. Make sure you're subscribed to John Brown Show, because now let's talk about why these compelled testimony orders were so devastating for Trump strategically. It's not just about the immediate threat of jail time. It's about what happens once Trump is forced to testify under oath. Because testimony creates a permanent record. Everything Trump says under oath gets transcribed. It becomes evidence that can be used in other cases. And Trump has a decades-long pattern of lying and contradicting himself. So if you force Trump to testify in one case, his testimony will likely conflict with statements he made in other cases. And those contradictions become evidence of perjury. Prosecutors can charge Trump with lying under oath by showing that his sworn testimony in case A contradicts his sworn testimony in case B, and at least one of those testimonies must be false. That's perjury, and that's exactly what prosecutors were trying to do in late 2025. They were forcing Trump to testify in multiple cases simultaneously so they could create a web of contradictory statements that would prove Trump was lying somewhere. And Trump understood this trap. That's why he was so desperate to avoid testifying. But the judges weren't giving him that option anymore. And here's why the judges changed their approach. For years, Trump had successfully used delay tactics to avoid testifying in various cases. He would file motion after motion, appeal after appeal, and by the time courts worked through all the procedural issues, years would pass. Witnesses would die or forget details, evidence would be lost, and cases would weaken or get dismissed. Trump's entire legal strategy was based on delay, but by late 2025, Judges had seen this pattern play out too many times. They understood that Trump's procedural motions weren't legitimate legal arguments. They were stalling tactics designed to run out the clock. So judges started rejecting the motions immediately and imposing harsh sanctions for filing frivolous appeals. Judge Engoron specifically wrote in one order that Trump's pattern of delay would no longer be tolerated, that the court had given Trump ample opportunity to comply voluntarily, and that further delay would be treated as contempt regardless of whatever procedural arguments Trump's lawyers invented. That's a remarkable statement from a judge, essentially saying that the court doesn't care what legal theories Trump comes up with. He has to testify, period. And that's when Trump realized he was trapped. So what did Trump actually do when faced with these testimony orders? Well, Trump tried to show up for some depositions, but refused to answer questions. He would sit for the deposition and then invoke his Fifth Amendment right against self-incrimination on every single question. Even basic questions like, what is your name? Trump would plead the Fifth, and legally that's allowed. The Fifth Amendment protects you from being forced to incriminate yourself. But here's the problem. When you invoke the Fifth Amendment in a civil case, the jury is allowed to draw a negative inference. They can assume that you refuse to answer because the truthful answer would be incriminating. So Trump's Fifth Amendment strategy doesn't actually protect him. It just makes him look guilty. And judges started telling Trump that explicitly. Judge Engoron told Trump during one deposition that his blanket invocation of the Fifth was not going to prevent adverse findings, that the court would draw all reasonable negative inferences from Trump's refusal to answer, and those negative inferences would support the fraud findings. So Trump's Fifth Amendment strategy was backfiring. He wasn't testifying, but he was still losing the cases because his refusal to testify was being treated as an admission of guilt. Share this with everyone and then Trump tried a different tactic. He started giving testimony but lying, just making up answers that he thought sounded good. And that's when things got really dangerous because prosecutors were prepared for this. They had documents and witnesses that contradicted Trump's testimony. So every time Trump lied under oath, prosecutors could prove it was a lie. And those proven lies became perjury charges. Trump testified in one deposition that he never personally signed financial statements that inflated property values. He claimed his accountants prepared all the financial documents and he just assumed they were accurate. But then prosecutors showed Trump his own signature on financial statements with handwritten notes in Trump's handwriting. Notes that showed Trump personally changed valuation numbers to inflate them. Trump was caught in a direct lie under oath, and prosecutors immediately filed perjury charges. And Trump tried to walk back his testimony. He claimed he misunderstood the question, that he forgot about those particular documents, but judges weren't buying it. They ruled that Trump knowingly lied under oath and that the lies were material because they related to the core fraud allegations. So Trump got charged with perjury on top of all his other crimes. And this perjury exposure is what ultimately forced Trump to stop testifying entirely. By December 2025, Trump's lawyers were advising him that he absolutely could not testify anymore, because every time he testified, he either incriminated himself by telling the truth or committed perjury by lying. There was no winning strategy. So Trump started simply refusing to appear for depositions despite the court orders. And that's when judges started issuing contempt sanctions. Judge Boasberg was the first to actually follow through on the contempt threats. On November 28, 2025, Trump failed to appear for a scheduled deposition in the deportation case, and Boasberg immediately issued a warrant for Trump's arrest. The judge ordered U.S. Marshals to take Trump into custody and hold him until he agreed to testify. And Trump's lawyers filed emergency appeals trying to block the arrest warrant. But appellate courts upheld it. They ruled that Boasberg had authority to enforce his orders through contempt sanctions, and that Trump's refusal to appear was willful contempt. So the arrest warrant stood. And for about 48 hours in late November 2025, there was an active warrant for Donald Trump's arrest. U.S. Marshals were reportedly preparing to execute the warrant, but then Trump's lawyers negotiated a deal. Trump agreed to appear for a limited deposition on specific topics if the contempt charges would be held in abeyance, and Boasberg agreed. Trump showed up for the deposition on December 2, 2025, and Trump invoked the Fifth Amendment on most questions. But he did answer some questions under oath, and those answers became part of the record that prosecutors are now using against him. Now here's where it gets really interesting. What does all of this mean for understanding Trump's legal collapse? First, it shows that Trump's traditional legal defense strategies stopped working in late 2025. For decades, Trump had successfully used delay appeals and Fifth Amendment assertions to avoid accountability. But judges finally stopped tolerating those tactics. They started imposing real sanctions, contempt charges, arrest warrants, immediate jail time. And once judges were willing to use those tools, Trump had no defense. He either had to testify and incriminate himself or refuse to testify and go to jail. There was no middle ground anymore. And that destroyed Trump's ability to fight his legal battles. Second, the compelled testimony orders created a cascading effect. Each time Trump was forced to testify in one case, his testimony created evidence for other cases. Prosecutors from different jurisdictions started sharing Trump's deposition transcripts. They would analyze the transcripts looking for contradictions and admissions, and they would use those findings to build cases in their own jurisdictions. So, one testimony order in New York would lead to new charges in federal court, and testimony in federal court would lead to new charges in state court. Trump was creating evidence against himself every time he opened his mouth, and that accelerated the pace of prosecutions. By January 2026, Trump was facing charges in multiple jurisdictions based largely on his own testimony from late 2025. The compelled testimony orders had turned Trump into his own worst enemy. Third, these orders exposed the limits of presidential immunity. Trump tried to argue that he couldn't be forced to testify while serving as president, that executive immunity protected him from judicial orders. But courts rejected that argument. Judges ruled that presidential immunity doesn't extend to personal conduct unrelated to official duties. And fraud, tax evasion, and money laundering are personal crimes, not official acts. So Trump had no immunity. And once courts established that principle, it opened the door to all kinds of enforcement actions against Trump. Asset seizures, arrest warrants, criminal prosecutions, everything. Because if Trump doesn't have immunity from testifying, he doesn't have immunity from anything else either. The compelled testimony rulings destroyed Trump's immunity defense across the board. Fourth, Trump's panic during this period was visible and damaging politically. Multiple reports from late 2025 described Trump as being visibly stressed and erratic. He was posting dozens of angry messages on social media about judges persecuting him. He was lashing out at his own lawyers for not protecting him. He was reportedly having trouble sleeping because he was so anxious about the testimony orders. And this panic showed weakness. Trump's entire political brand was built on projecting strength and confidence. But when judges started threatening to jail him, Trump looked scared. And voters noticed. Trump's approval ratings dropped significantly in late 2025, and political analysts attributed it partly to Trump's visible panic over the testimony orders. People don't want to follow a leader who looks terrified of judges. They want someone who projects confidence and control, and Trump was projecting neither. He looked like a desperate man trying to avoid accountability, and that image undermined his political support. Fifth, the testimony orders created rifts between Trump and his legal team. Multiple lawyers quit during this period because Trump wasn't following their advice. Lawyers would tell Trump not to testify or to limit his answers, and Trump would ignore them and ramble during depositions, making incriminating statements. Or Trump would refuse to show up for depositions despite his lawyers negotiating agreements for him to appear. And that would make the lawyers look bad and expose them to potential sanctions. So lawyers started quitting. By January 2026, Trump had trouble finding any reputable attorneys willing to represent him, because representing Trump was professional suicide. You'd give him legal advice, he'd ignore it, then he'd blame you when things went badly. No competent lawyer wanted that. So Trump ended up with increasingly marginal legal representation. Lawyers who were desperate for clients and willing to take Trump despite his reputation. And those lawyers weren't good enough to handle the complex legal battles Trump was facing. So his legal defenses got weaker and weaker as his legal team deteriorated. Finally, the compelled testimony saga shows that courts eventually enforce their orders when defendants push too far. Trump thought he could defy judicial orders indefinitely, that judges would keep giving him chances, that the system would tolerate his delays and non-compliance, but he was wrong. Judges have enforcement tools, contempt sanctions, arrest warrants, asset seizures, and when judges finally decided to use those tools against Trump, he had no defense. The system worked slowly, imperfectly, but it worked. Trump was forced to testify. He was caught lying under oath. He was charged with perjury and contempt, and those charges contributed to his ultimate downfall. The compelled testimony orders from October through December 2025 were a crucial piece of Trump's legal collapse. They forced Trump into impossible situations where he had to choose between self-incrimination and contempt, and either choice was devastating. So Trump tried both. He testified sometimes and lied, creating perjury exposure. He refused to testify, other times creating contempt exposure, and both decisions led to charges. By January 2026, Trump was facing perjury charges, contempt charges, and all the underlying fraud and money laundering charges. The testimony orders had multiplied his legal problems exponentially. The bottom line is this: the compelled testimony orders from late 2025 destroyed Trump's ability to avoid accountability through delay and procedural maneuvering. Judges imposed tight deadlines, threatened immediate jail time, and enforced their orders through contempt sanctions. Trump had to testify in multiple cases. His testimony created contradictions and admissions. Those statements became evidence for new charges. Trump committed perjury by lying under oath. He committed contempt by refusing to appear. And he incriminated himself when he told the truth. There was no winning strategy. And by January 2026, Trump was drowning in legal problems that stemmed directly from his compelled testimony. This is a story about how courts can eventually overcome even the most determined attempts to obstruct justice, about how delay tactics only work until judges decide to stop tolerating them, about how testifying under oath is incredibly dangerous for people who've built their lives on lies, and about how Trump's decades of fraud finally caught up with him when judges forced him to answer questions under oath. Trump couldn't lie his way out, couldn't delay his way out, couldn't appeal his way out. He had to testify, and his testimony destroyed him. That's justice. Slow, frustrating, but ultimately effective. And that's what these compelled testimony orders represented. The moment when the judicial system stopped letting Trump play games and started forcing accountability. And once that shift happened, Trump's collapse was inevitable. This story continues. Stay tuned.